Hi everyone, welcome to an update on commercial landlord and tenant COVID-19 rent arrears. My name's Kate Halifax and I'm part of the real estate disputes here at HCR, and I am joined by Andrew Walker.
Yes, hello everyone. Andrew Walker, partner and head of real estate disputes.
So as you can probably tell from the job titles, we've been dealing with a lot of landlord and tenant commercial rent arrears, and the purpose of this video is just to kind of talk about some of the last changes, well, some of the most recent changes since we last spoke about this topic, which I think was back in March, April this year. Now, I think on the one hand, quite a lot has happened, but yet on the other hand, standing back, maybe not quite as much as we thought. So I think the main thing in this sector has been the restrictions that the government have imposed on landlords, essentially restricting what they can do when a tenant is in commercial rent arrears. So obviously, Andrew, the first one, as we well know, is the restriction on forfeiture.
Yep.
For arrears of rent. So that has been extended by the government. It was due to end in the summer, and that's been extended until 25th of March 2022. Same with restrictions on CRA, so commercial rent arrears recovery, again, been extended until 25th of March 2022. And then we thought landlords were going to get a bit of a break when the government was partially lifting the restrictions in relation to winding up petitions. However, commercial rent arrears are classed as an excluded debt, and the relaxation of the rules on winding up petitions do not apply to commercial rent arrears. So short point is, landlords, you can't present a winding up petition when your tenant is currently in rent arrears. So Andrew, what do you think about that?
Well, it's not very helpful from a landlord's point of view. And actually, bearing in mind the lifting of restrictions on winding up petitions for other types of debts, I saw an interesting note recently. So a creditor of the tenant, another creditor of the tenant can go for winding up petitions. The landlord can't, and therefore the other creditors are getting a head start on this, aren't they, in terms of being able to take some of the tenant's assets. It doesn't seem very fair, but
I think if you're speaking to landlords recently, I think it's not fair is something that's probably rolling quite readily off the tip of their tongue at the moment. Indeed. But I suppose it all depends. Well, I mean, the good news, Kate, there have been a flurry of cases which have gone through the courts, which have confirm that the landlord is entitled to sue for the rent. He can still do that. There were a number of points which came up. I think various tenants have tried to imply terms into the lease so that they could avoid paying the rent during COVID periods. They've tried to argue frustration, etc. But none. I'm not aware of any reported case. I don't think you are either, Kate, are you? Of any reported case where the landlords failed to get a judgment for rent. No, you're absolutely right. So for those of you that may not be familiar, Andrew's referring to the three key cases that have all been heard. I think they've all been heard by way of a summary judgment application as well. Yeah. So that means that they've not gone the full length to trial, which is good because it's a quicker way to force the issues, save time and cost involved going all the way to trial. So firstly, we had the TFS stores case back in April, then we had the Mellon case, and then more recently as well, we've had the London Trocadero case versus Picture House Cinemas. And as Andrew has said, each one of them has tried to raise arguments in relation to why they should be allowed to, well, in relation to what gives them a defence to the landlord's claim for rent arrears. And it's included everything in terms of, well, the landlord had insurance, so that should be its remedy. The damage that was caused, so where you have an insured risk provision and damage is caused to the property.
then that should extend to a period of lockdown rather than just physical damage. That's not been successful. The fact that the parties have failed to follow the code which the government introduced in 2020 for landlords and tenants to follow to resolve commercial rent arrears hasn't been followed. That's not been successful either. So at the moment, there is not one successful case, as Andrew said, where tenants have been able to validly defend a landlord's claim for rent arrears. I think the Mellon case is currently on appeal, so whether or not that is successful, we shall wait and see. But at the moment, that's about it, really.
Yeah, it's not great. It's not great, I'm afraid. I mean, one point to remember for landlords is they can forfeit for other breaches of covenant. What we're talking about is just commercial rent arrears. So a landlord faced with commercial rent arrears, he can't do a winding up petition, he can't forfeit, he can't CRA, he can sue for the debt in the courts. But then, of course, we're looking forward, aren't we, Kate, to
Yes.
what the government have indicated, but provided few details, of a new regime for dealing with, if we call it, the COVID arrears?
Yes, you're completely right. So earlier on, we were just mentioning that one of the arguments tenants have tried to raise in the courts is that because landlords haven't followed the code of practice, which was introduced by the government last year, which essentially encourages landlords and tenants to work together to, reach some form of agreement to suit both their needs in respect to the rent arrears, then they shouldn't be awarded judgment. But the point is, the code that's currently in force has no teeth. So what the government are looking at doing, and we don't know exactly when, apparently it's this parliamentary session, looking at introducing a code with teeth, essentially. So this is going to be a code of practice which is going to be formally brought into legislation, essentially making landlords and tenants enter into a binding arbitration where they cannot agree on how to deal with the rent arrears. And one of the interesting things about the code, well, the new code, as it were, or the code with teeth, is that, well, at the moment, there's not really a lot of information out there about it. So we know that there's going to be a binding arbitration process. Okay, who is going to act as arbitrator? I understand that the parties are going to be expected to share the costs of that unless the arbitrator deems that one party's conduct warrants a costs order against it. But one of the interesting things is, how are they going to assess specifically what of the COVID arrears are caught by this arbitration? Because they're talking about COVID-19 arrears as a result of business closures because of restrictions in the sector. Well, if we cast our minds back to, I think it was about almost this time last year, where the government introduced its tiered system, you had different restrictions applying all over the country.
I think you're absolutely right, Kate, because I mean, COVID kicked off, I think we're pretty clear it's March 2020, but when there was a date in March 2020 when it kicked off. We've then at the other end got the last lockdown, whenever that ended, I don't recall, but there is that overall period. But what about, as you rightly say, the periods in between when the government didn't require people to shut? And also, what about within that overall period where the government wasn't requiring you to shut, but for good and sensible commercial reasons, it wasn't worthwhile you opening up for a month or two? Is that within the COVID arrears, which would be caught by the arbitration provision?
Yeah, exactly. I think
certainty.
Yeah, it'll be really interesting to see if that is defined at all in the legislation. I think we'll just have to wait and see. But another hurdle as well is the government has made it very clear that where a tenant can pay, it should pay. Well, again, how exactly is this going to be assessed? It's almost like there's going to need to be a form of forensic accounting involved to assess whether or not some form of deal is going to be viable. Because I mean, the last thing a tenant wants to do is deal with something which is just financially unworkable, because otherwise they're going to be straight out of the frying pan and into the fryer, really. It's not really going to get them any further forward.
I think that's right. We don't know what type of powers or criteria are going to be given to or should be applied by the arbitrator. It's very much up in the air. If there is a smell of something, Kate, and you and I have touched on this in discussions, the smell is of a discount perhaps being imposed on the landlord in respect of those COVID arrears.
Yeah, and I think that definitely seems to be where it's going. And taking a step back, looking at arbitration, I mean, this is going to be binding. So I think that, you know, the focus really is on, if you want to retain some control as landlord, maybe try and enter into discussions now and try and do a deal which is going to be most palatable, really. But I think that the one positive about this is that at the moment the restrictions are very much, the current restrictions very much apply to commercial rent arrears. They're not split out by sector or who can pay or who can't pay. So there are going to be some tenants, and we have seen this, who aren't paying just because they're taking advantage of the current restrictions and the protections, that are going to become unstuck very quickly when the rules relax and the code come in, because the code won't apply to them if they didn't have to close. So that's something, is that it's going to start picking off certain tenants. So that's something, I guess, but I think until we know more, there's not really much more we can add at this stage.
I think that's fair. I mean, I suppose looking forward, if I was wearing my landlord hat, I think I would be still sitting down, negotiate with your tenant, find out what their real financial position is, and be sensible, objectively be sensible, see if you can strike a deal. If you reach the conclusion that that tenant does have money but isn't paying, you might then want to consider debt proceedings. We've talked about those, and pushing those through, and the courts have already indicated one should obtain a summary judgment. That's getting a judgment at an early stage in the proceedings. And before, and none of us know when these arbitration provisions are going to be imposed, before one would be subject to the arbitration process. It's one thought.
Yeah, and also you touched on an interesting point there. So what is going to happen if there are active debt proceedings for these arrears that would be caught by the arbitration process, and those court proceedings are ongoing when that arbitration process comes into force? Will they be stayed? Will they be allowed to run their course? We don't know.
No, we don't. We don't. And I suppose then wearing a tenant hat. With this legislation which is coming in and the uncertainty it's creating, now might be the time to strike the negotiations with the landlord to achieve a deal. And if you were being a tenant and saying, I'm not going to pay you anything, maybe you can use the inherent concern which the arbitration process is going to create, probably more likely for the landlord, use that concern to try to strike a compromise with your landlord. Otherwise, as I said, the landlord might be tempted to go into court proceedings, and you, the tenant, would not then, subject to whether you conclude those proceedings before the arbitration provisions come in, you, the tenant, would be subject to those proceedings and not have the potential benefit we anticipate you might get in the arbitration.
Yeah, and I think that a key takeaway point as well is that the government has said that it is going to still expect these discussions to be ongoing between landlords and tenants before the arbitration process. The arbitration process is very much seen as a last resort. So I think just trying to have those conversations is key, but we know that in some cases that is easier said than done. So we'll see what happens, I think. But I mean, you know, all is not lost. There are still some remedies out there for landlords, and that is obviously forfeiting for other breaches of the lease, you know, court proceedings we've touched on. considering whether there are any guarantors, drawing down on rent deposits, etc. I mean, I appreciate that given how far down the line we are on this, some of those avenues may have already been exhausted, but it's still worthwhile that, if you're a landlord or even a tenant and, you want some advice on where you stand, take a step back, look at it in the round and see what you can do, and also then commercially what you can potentially achieve in discussions with the other side.
I think that's absolutely right, Kate. And to add one thing, there's a little bit of teeth here potentially to encourage both parties to negotiate. I've seen it written that in the arbitration, the arbitrator may well be able to take account of both parties' conduct pre the arbitration and whether they behave reasonably in the negotiations, and then make an adverse order on cost against the party who was, shall we say, obstructive. So it's worth keeping that in mind.
Yeah, negotiating in good faith is, again, something that they're going to expect. So you can kind of see very much where the government is with this. They want people to engage. They want people to do it now. Yes, they are providing arbitration, but that is very much a last resort. And if you're not playing ball, you could suffer the consequences, really. So I'd say try and strike now. At the moment, we're looking at some uncertainty. And I think we'll just have to keep an eye on it, really, and see what happens. But I do think that given some of the concerns we've raised with the arbitration process and how certain things are going to be dealt with, well, I think there's going to be some fun and games ahead of us.
Well, I think you're absolutely right. I think it very much is watch this space, and Kate and I will be watching it very closely. And when we can cast more light on it, guess what? We're going to come and talk to you guys again.
Yeah, exactly. And well, I think, Andrew, I don't really think there's any more for us to say on the topic, really. So I think let's just leave it there. And like you say, we will be in touch again soon, and hopefully you've enjoyed hearing us kind of talk about the latest on this topic. So thank you very much for listening all.
Cheers. Bye.